A great condo or HOA manager removes burdens from your shoulders as board members. The question is, however, are there things you shouldn't be asking your manager to take off your hands? In this month's HOAleader.com video, two of our experts answer that question. Welcome to this HOAleader.com video chat with two of our experts. My name is Gabriella Flisco. Today, I'm joined by Brad Van Royen and Karen Marcel, both of Florida. And rest assured, they're both from Florida, but if you're not in Florida, you will find this information useful. So we're covering this topic to help out an HOAleader.com reader in Florida. And they say three of their board members are pretty inexperienced. And our reader thinks they rely too much on the manager for solutions. For example, Florida law requires that any fining committee created must have three members independent of the board. So in this case, the board couldn't recruit three people to fill the committee. So the manager recommended the board just pass a resolution and giving the property manager the ability to do the fining process. And then also the reader says the manager has issued architectural review denials along with violations and fines. So in this video, we'll address whether in states or documents that require that there be committees separate from the board, would it be acceptable to shift that committee role to the manager? Just a note, our experts are providing insights based on the laws in Florida and the practice in the states they're authorized to practice in. And this is intended to provide you with general guidance you can use to help you when you approach experts in your state. So with that long introduction, Brad, you're the community association manager. In your experience, would this shift of authority this board has done be acceptable? Would you accept it as a manager?
Absolutely not. Not only is it out of our scope, but it also violates the law. The law is very clear, and I'm sure Karen's going to, cite what that law is for us. But managers should never take on the responsibility of the board's duty. The role of the manager is primarily to advise, and to assist the board, to bring them solutions, to keep them in compliance, but not to do the job of the board. And I know that can be sometimes very difficult because there is sometimes, as we've spoken in the past, there is apathy in communities, and there's a lack of volunteers. But that lack or apathy should never result in the manager stepping outside of their legal bounds, and taking on the role that is prescribed only to the board of directors.
Karen, what do you think on this?
Okay, so there's several issues here that are very concerning from a legal standpoint. The first being that the statute is extremely clear on the fining process. And the fining has to be done by a fining committee of three members who are not related to a board member. And it's very clear as to how that's supposed to occur. You're supposed to give an owner a 14-day notice of a hearing. And it is the fining committee who makes the decision to whether a fine is going to be imposed or not imposed. And in fact, if they decide not to impose it, the board cannot do anything about it. And what's happening here is the manager is basically giving some legal instruction to this board saying, hey, do a board resolution. That's always concerning because he is now crossing lines. So number one, obviously, when you're talking, and every state's different regarding their fining requirements. So number one is you need to make sure you're following the parameters of the law. And if you don't know, ask an expert, ask an attorney. Most associations do have general counsel. Secondly, there's other means by which an association can actually address these violations. They can send violation notices to the owners. And, Florida is a big advocate for alternate dispute resolution. There's even a statute out there that indicates, hey, if you guys have a specific issue, you can go do a pre-suit mediation. So if the fining committee cannot be put in place because you can't find three members or owners in a community who want to sit in a fining committee, which is very understandable because you don't want to become persona non grata in your own community, there are other alternatives. You can have a legal letter sent, the manager can send violation notices saying, hey, you're in violation of these documents, we're giving you these, a specific amount of time in which to comply. If that fails, we're going to have to hand it over to legal, offer the alternate dispute resolution. Ultimately, if that fails, you can file a lawsuit against them and then actually have at least the court basically saying what you can and can't do. But in Florida, the fining statute is very specific. The other
Okay.
the only other thing I would throw out, and I'm sorry, I know lawyers always talk, but there is a very clear statute in Florida. I suspect they are in other states as well, where it indicates that a manager cannot blatantly just listen and try to please the association if it's against the legal requirement. So in this case, they're actually violating their own professional regulations, which Brad can also discuss.
All right. Well, thanks for that. Great information. Listeners, please be sure to click the link below to watch the additional extended video where these experts address the broader issue of which board duties can you shift or should you shift and which should you not shift to your manager.